Assalamualaikum warahmatullahi wabarakatuh to Madam Asnalisa Arma and my beloved friend. So my name is Muhammad Aiman Firas bin Rashidi. My metric number is TIL231305. So today I will present about breach of director duties. Directors are important for business management because they make sure business follow the law and moral principle. They have legal and fiduciary obligation requiring them to work in the best interest of the company to avoid conflict of interest and safeguard private data. These obligations are outlined in Companies Act 2016 of Malaysia, which also prohibit the unlawful use of corporate assets and require disqualification for specific acts. So, Tanjak Gagal Sdn Bhd is a company involved in manufacturing and selling beauty products under the brand of Gorgeous Gitu. Advise the company whether there is any breach of director duties. So, last week, the company appointed Datuk D as the board of directors. Chantik, a shareholder, has discovered that Datuk D was convicted of fraudulent trading 5 years ago when he was director of Bling Bling Sdn Bhd. Secondly, Tanjak Gagal Sdn Bhd has discovered that his former director for research in Tanjak Gagal Sdn Bhd, Mok Chun, has incorporated a company in March 2020 that sells similar skincare products like Gorgeous Gitu. Tanjak Gagal claimed that the formula for these products were taken by Mok Chun from Molek database when she resigned. On the other hand, Mok Chun claimed that the product were the result of her own skills and experience gained in industry for numerous years. Mok Chun claimed Mok Chun company had hired former employees of Tanjak Gagal Sdn Bhd who were involved in research and they found a new formula for the new product. So illustrate your answer with relevant case and statutory provision in the Companies Act 2016. Use the ILAC to answer the question. So next is issue whether the appointed of Datuk D, who was previously convicted of fraudulent trading, breached the duties of Tanjak Gagal Sdn Bhd directors. And secondly, whether the Mok Chun breached her duty by former director incorporating a competing company that allegedly used the confidential formula belonging to Tanjak Gagal Sdn Bhd. So next is law. In section 198(1)(c), disqualification of directors. So secondly is section 2131 is the duty to act in the best interest of the company. Third one is section 2218(1)(d), duty to avoid conflict interest. The fourth one is section 221(1), to duty to maintain confidential and prevent competition. So for the case of Tengku Datuk Ibrahim Petra versus Petra Perdana Sdn Bhd. So the issue is whether the director breached their duty to act in the best interest of the company when they sold shares of Petra Energy Sdn Bhd, Petra Energy Berhad PEB, claiming it was necessary to resolve liquidity problem. So the federal court held that the directors act in a good faith and in the best interest of the company. The sale share was justified by the company liquidity needs and there was no evidence of personal gain or ulterior motive. So the court emphasized that the director's decision should be assessed both subjectively and objectively. So next case is Board of Trustees of the Sabah Foundation versus Datuk Syed Kecik. So the issue is whether Datuk Syed Kecik breached his fiduciary duties by failing to disclose his interests in a project and by allegedly misusing confidential information to benefit his personal company. So the federal court held that Datuk Syed Kecil did not breach his fiduciary duties in relation to one of the projects as he acted in good faith and did not misuse trust information. However, in another appeal, he was found to have breached his fiduciary duty by applying for a timber license without informed consent. So it leading to a conflict of interest. The case reinforced that directors might not use company information for personal gain without the company consent. So next is for application. So appointment of Datuk D. So in section 1981 of the Companies Act 2016, clearly disqualifies individuals from serving as directors if they have been convicted of fraud or dishonesty. In Datuk D case, his conviction for fraudulent trading 5 years ago at Bling Bling Sdn Bhd directly violate this provision. So by appointing Datuk D as a director of Tanjak Gegar Sdn Bhd, it has failed to comply with the statutory requirement for director eligibility, and this could expose the company to legal consequences including potential shareholder action to contest the appointment. And moreover, in section 2131 requires that directors act in good faith in the best interest of the company. When appointing new directors, the existing board has a duty to ensure that the appointee background does not pose a risk to the company reputation, operation or compliance with the law. So appointing someone with a fraudulent past such as Datuk D does not demonstrate an exercise of reasonable care or judgment, as a director convicted of fraud may be perceived as untrustworthy, thereby damaging the company credibility in the marketplace. So the company directors may also face criticism for failing to conduct due diligence when considering Datuk D appointment, which would reflect poorly on their judgment and could undermine shareholder confidence in the board leadership. So using the case of Tengku Datuk Ibrahim Petra versus Petra Perdana Sdn Bhd, it reinforced that directors must meet both subjectively and objective standards in performing their duties. Objectively, a reasonable board would like to avoid appointing a convicted fraudster, as doing so could expose the company unnecessary risks. So subjectively, the directors in this case may argue that they believe that D could offer value to the company, but the objective standard of acting in good faith and avoiding unnecessary risk to the company would likely outweigh this argument, especially given his disqualification under the law. So next is action of Mok Chun. So under the section 218 of the Company Act 2016, it prohibits a director from using company property or information to benefit themselves without company consent. Mok Chun Incorporate, a competing skincare company, present a direct conflict of interest, particularly because Tanjak Gegar Sdn Bhd claimed that she used their confidential product formulas to develop her own line. If this formula were indeed proprietary information stored in Tanjak Gegar database, then Mok Chun has violated her duty to avoid exploiting company resource for personal gain. So the misuse of confidential information could result in legal action against her for breach of fiduciary duty. But however, Mok Chun contends that the products she developed are based on her own experience and that she did not misuse any proprietary information from Tanjak Gegar. While it's common for individuals in the same industry to use their accumulated skills to start new ventures, the key issue here is whether the formula she alleged use were developed solely through her skills and knowledge if they were derived from Tanjak Geger confidential research. So in the case of Board of Trustee of the Sabah Foundation versus Datuk Syed Kecik, the court highlighted that directors must not use confidential information belonging to their previous company for personal benefit. If it can to be proven that Mok Chun did not use Tanjak Geger property formula without the authorization, she would have breached her fiduciary duties. And also furthermore, in Section 221 requires directors to disclose any conflict of interest. The Mok Chun should have disclosed any intention of engaging in a similar business during her time at Tanjak Geger. If she failed to disclose her involvement in setting up competing company, this would further indicate a breach of her fiduciary duties by hiding a conflict of interest. Even if Mok Chun argues that her product were created independently, her hiring of former Tanjak Geger employees who work in research could suggest that she intentionally relied on inside knowledge gained from the company resource. Such conduct would be considered highly questionable, and it will view as an indirect exploitation of the company proprietary information and expertise constitution a breach of statutory duties under Section 218 and 221. So lastly, in conclusion, there is a clearly breach of director's duties in the appointment of Datuk D, as his prior conviction for fraudulent trading disqualified him under Companies Act 2016. Additionally, Mok Chun is guilty of breaching her fiduciary duties by using Tanjak Geger Sdn Bhd confidential formulas for personal gain and failing to disclose her conflict of interest when establishing a competitive business. So her action not only violates the statutory provision but also undermines the trust placed in her as a former director, so exposing her to a potential legal repercussion. That's all from me. Thank you.